Before moving to ground two, can I just spend 5 minutes summarising where I think we've got to in respect to 592? Certainly, so you understand my position clearly.
Yes.
There are three possible interpretations of 592, it seems to me.
Yeah.
The first is that Mr. Andrew was party to the overarching scheme in paragraphs 495 to 6. If that's the right interpretation, that was an allegation that wasn't pleaded or put, and no reasons are given for it, and it cannot stand. The second possible interpretation is that the finding of the reference to prepared to use corruption in 592 does include Mr. Andrew, but it's limited to his treatment of the internal documents. Now, we say, in response to that, to interpret it in that way is odd, because it requires you to use corruption in two different ways, but also odd because it requires you to read between the lines as to what the judge must have meant or must have implied. But even if you don't like those submissions, that second interpretation isn't open to Nigeria to uphold for the following reasons. It's a point that wasn't pleaded, I'll take you to that, and it's a point that wasn't put. So it was never said against Mr. Andrew that he had been monitoring their internal documents with a view to personal gain. As against him, the pleading was restricted to the allegation that he failed to reveal to Nigeria that he had them. That was as far as the pleading went. And it's important I show you that, so I overlooked it in sort of the heat of the moment this morning. Can we look at what Nigeria said against P&ID, which you'll find at Core Bundle 15, page 362. We go to 79J. Where it said against P&ID, that P&ID was making use of the documents to gain knowledge of what FRM was being advised and the steps it was planning on taking, and or to obtain improper and unfair strategic and tactical advantage, and or three, influence and seek to influence via the corrupted individuals the steps the FRM was or was not taking. That's an allegation against P&ID only. It's not an allegation against Mr. Andrew. Can we go on to 79K, where it's expressly pleaded that they got comfort that Nigeria did not know of the bribery. See that in the first four lines, and that Nigeria didn't know that Michael Quinn's evidence was perjured. As against Mr. Andrew, the only pleading is at 79I on above on 362. At no time did Mr. Andrew, Mr. Burke, reveal to FRN or to the tribunal that P&ID had been and was being improperly provided with privileged and or confidential documents and information belonging to FRN. Further, the withholding of the documents and or concealment from FRN are the full and true facts. Was a cause of the continued concealment from FRN and the tribunal. So it's not said that he misused the documents in any way whatsoever. Moreover, the highest it was put to him in cross-examination was that that when he received the documents, he either knew or turned a blind eye to the fact that they'd been improperly obtained. No allegation was put to him about misuse of the documents. In those circumstances, we say it would be quite improper to read the particular paragraphs we've been discussing in the judgment as implicitly finding against Mr. Andrew that he did something that was never alleged against him, namely use those documents improperly. And on top of that, no proper reasons. If option 2 is the correct interpretation of 592, the judgment is just devoid of reasons in that regard. And you ought to know, I won't take you through this in any detail, you ought to know that Mr. Andrew, in his witness statement, he spent 90 paragraphs on dealing with his receipt of documents. You'll find that, just so you'll note, it's the core supplementary bundle starting at page 4. And you'll see a subheading at the bottom of that page, the unsolicited receipt by me of internal documents. Now he spends 90 paragraphs dealing with each of the documents that he received and explaining what he did, what he thought of them and what he did with them. Now, the judgment is completely silent on his evidence about this. It just doesn't engage with it at all. And that becomes particularly odd, particularly odd when the judge starts his judgment by saying that Mr. Andrew tried his best to answer questions carefully and accurately. And that's paragraph 207 of the judgment, which you'll find at page 123 of the core bundle. It said, 3 lines at the bottom, Mr. Andrew tried his best to answer questions carefully and accurately. Now and time doesn't permit me to go through the detail of this, but what then happens in the judgment, the judge identifies 16 of Nigeria's internal documents in the judgment, only 6 of which were received by Mr. Andrew, and 1 of which was clearly received by a proper channel, even though it was privileged. All I propose to do is give you the paragraph references and invite you to read them, because at no stage does the judge make a finding that Mr. Andrew misused these or put these documents to any use. Paragraphs, judgment paragraphs 256, page 133, 275, page 138, 282, page 140, 293, page 142, 325 on page 151, and 336 on page 153. Now, Mr. Andrew didn't deal with that last of the 6 in his evidence. He dealt with all of the other 5, and no reasons are given at all. So the second interpretation of corruption at 592, I say, would be a clear breach of his Article 6 and 8 rights. Not pleaded, not put, and no reasons given. And no attempt at all to deal with the very voluminous evidence that Mr. Andrew deployed in answer to the limited allegation that was levelled against him. And what he was doing, he was trying to explain why he didn't think the documents were of any real importance or relevance. So the third possible interpretation of 592 is that the reference prepared to use corruption is not intended to be directed at Mr. Andrew and is limited to the corrupt scheme in 496 and 7. If that is the view the court takes, then we would invite the court to say so. So that summarises all I wanted to say about, or summarise where I think we got to at the end of this morning in respect of ground 1.
Yeah. Okay.
So I'm now going to turn to ground 2.
Yeah.
Ground 2 relates to the judge's finding that Mr. Andrew's failure to return the internal documents was indefensible. Before I turn to the finding, we should perhaps start by looking at why Mr. Andrew's duty to return the documents was an issue at all. Can you turn up, please, call bundle, page 508. And it's paragraph 37E. And it's really, the key paragraph is over the page.
Sorry,
Sorry, my lord.
page 508, you say?
Yes.
This is 37E of the reply.
Yes, it is. Thank you.
506.
It starts at 506, thank you.
Yeah, which bit do you
And
want to
over the
read?
page, it's points 1 to 6, a number of different facts are pleaded as to why Mr. Andrew would have known the documents had been improperly or unlawfully obtained. The key paragraph is at subparagraph 7 over the page, where it said, as to the final sentence, it averred that Mr. Burke and Andrew were under a professional and or legal duty as soon as they became aware that the documents contained privileged and confidential information, that the documents had been obtained improperly and through collusion, 1, not to read, 2, to return, etc. So that's the allegation. That's how they put his duties. It's either legal or professional and or professional duty. And you've already seen how the judge deals with that in his finding at judgment 215. We don't need to turn it up again. He says the failure to return was indefensible. So the finding is that Mr. Andrew knew they were confidential, some of them were privileged, but not how they had been obtained. And the judge finds on that basis he was duty bound to return them, and his failure to do so was indefensible. And we say that that breached his Articles 6 and 8 rights in 2 ways. First, that the judge failed to give adequate reasons for such a finding. And secondly, because the judge didn't give Mr. Andrew fair notice that he planned to make such a finding, which was in any event unnecessary to the actual disposition of the case. Now, as for the first, the failure to give reasons, the judge doesn't explain why Mr. Andrew was under a duty to return the internal documents. It is far from obvious, we would submit, that a solicitor whose client sends in privileged material of allegedly improper provenance or possibly improper provenance is under a duty to tell the other side about it and to return those documents. In the circumstances, the procedurally fair course of action would have been for the judge to explain the basis of such a duty and to at least attempt to address the complex law on the matter. The complexity of the legal position arises from the fact that a solicitor in Mr. Andrew's position owes duties to his client. These were documents provided to him by P&ID, presumably with the intention that they should be kept confidential. And of course, prima facie, solicitors cannot freely disclose material to the other side, which is subject to their client's right to confidentiality. And the actual communication of these documents to Mr. Andrew was also on the face of it privileged. Therefore, if he had a duty to return to Nigeria, then he was faced with competing obligations. And in order to determine the appropriate course of action for a solicitor in this situation, the judge would have to define with some precision the basis of the duty to return. And the starting point would have been to establish whether this was a legal duty or a professional one. Although Nigeria's pleading refers to legal and or professional, in practice it was only put to him that he was in breach of his professional duty. We don't need to look it up. You can get that from the footnote 172 of P&ID's written closings, which is the core supplementary bundle at page 285. Now, when the judge found that Mr. Andrew knew that they and P&ID weren't entitled to see the documents, he didn't say whether it was a consequence of the law of privilege or confidentiality. He didn't say whether it was a legal duty or a professional duty or both. It's simply impossible to say what he had in mind. And we say the proposition that we've seen in the reply is not in fact supported by the authorities. Nigeria rely on a case called LVK. However, the cases that are most on point are White and Withers and Immerman and Chengris. Now, these were both family cases, where a spouse had illicitly obtained the confidential documents of the other spouse and handed them to their solicitors in the divorce proceedings. The question that arose in both cases was whether a spouse who complied with the so-called Hildebrand rules was immune from an action in damages. In essence, as I'm sure you know, the Hildebrand rules provide that in the family courts, documents illicitly obtained by a spouse should be handed over at the disclosure stage to the solicitors on the record of the other side, who will then sort them for privilege and ensure that anything disclosable is in fact disclosed in the divorce proceedings. One can see from the judge, well, I don't need to look it up, that had given rise to a practice of solicitors positively advising their clients to obtain documents in this way. Now, when the well-known chef Marco Pierre White discovered via the Hildebrand protocol that his wife had illicitly obtained a number of his confidential documents, including some which were privileged, he brought proceedings against both his wife and her solicitors for breach of confidence, misuse of private information, and trespass to goods. And Mr. Justice Eadie in the High Court and then the Court of Appeal, comprising Lord Justice Ward, Wilson and Sedley, established two important principles. First, the wife in such a situation wasn't immune from the normal civil remedies just because she complied with the Hildebrand rules. And secondly, and most importantly for these purposes, no action could lie against her solicitors for the mere receipt and retention of the documents. We find that in the first instance decision.
Well, can we have a look at that, please?
Of course, it's page, bundle, tab 23, page 1555. Tab 53, did I misspeak?
Sorry, which tab?
53, I'm sorry if I said 23. Paragraph 8, Mr. Sherburn submitted the mere receipt of documents by the solicitors from their client and their continued retention in connection with the matrimonial proceedings simply cannot give rise to a cause of action, nor could the fact that such documents have been read and noted in connection with the litigation. Whilst it's true there has become recognised over the last few years a wrong, actionable in English law described as misuse of private information, following from the consideration of relevant principles by the Lordships in Campbell, it would not be possible by any stretch of the imagination to characterise the solicitor's receipt and retention of documents from Mrs. White in that way. And in the Court of Appeal, we go to paragraph 23 of Lord Justice Ward's judgment at 1570, tab 54. And it said there in the second sentence, in my judgment, Mr. Crystal was clearly right to take that course. Mrs. White's communication of that confidential private information to her solicitors for their use in the litigation could never be characterised as misuse of it. And nor was it an actual wrong on the part of the solicitors to copy, read and note the contents of the documents. We get that from paragraph 53 of Lord Justice Ward's judgment at 1581. Perhaps I want to look at the head note of the first instance decision at tab 53, page 1552. And it's the second holding there. So that's what White and Withers says, and the claim against the solicitors would have been struck out altogether but for two triable issues. Mr. White was alleging that Withers had positively requested their client to take his confidential documents, and B, some of the documents they retained were originals rather than copies. And a similar issue came up in the Immerman dispute before a differently constituted court of appeal. And the court there, and this is Lord Justice Newburgh as he then was, and Lord Justices Moses and Mumby. The court there,
Which tab?
tab 27,
Right.
starts at 717. Can we look at 752, please? In paragraph 70, they were taken to the observation of Mr. Justice Eadie in White and Withers that I've taken you to, the mere receipt of documents, etc. And they say, in our view, that observation, which may in any event have been limited to a cause of action and damages, should be taken as applying only to the receipt of documents by solicitors from the client. Further, it should not be taken as suggesting that the claimant could not recover the documents from the solicitors. So, there's no suggestion in Immerman of a positive duty owed by a solicitor to return or to volunteer to the other side the fact that they've seen or been provided with confidential or privileged documents by their client. On the contrary, the Court of Appeal in Immerman expressly reproved the ratio of Hildebrand as formulated by Lord Justice Wilson in White and Withers. If we can go to paragraph 41 at page 744. So at 41 at page 744, dealing with the time when you have to disclose documents. And there's a then summary where it's set from White and Withers, where it's said that the ratio decidendi of Hildebrand relates only to the time at which copy documents thus obtained should be disclosed to the other side, namely no later than at the normal disclosure stage, and thus in effect at the time of service upon that spouse of the first questionnaire. We respectfully agree Hildebrand, in our judgment, is authority only as to the time when copies obtained unlawfully or clandestinely should be disclosed to a spouse. On that narrow point, what we referred to as a rule in Hildebrand, it was and remains good law. Now, in an arbitration, of course, there's no disclosure stage at all. Therefore, Mr. Andrews' decision to retain the documents but not to use them was on the face of it within the ambit of what it was proper for him to do on the basis of these two authorities. So on the basis of White and Withers and Immerman, how does L&K fit in? This is the case the other side rely on, and we find that at I'm sorry, my lord.
Which case?
It's L&K, and you find that in tab 30 at page 834. Decision of Mr. Justice Mostyn, another case of a spouse illicitly obtaining the documents of the other spouse from her husband's safe in the course of divorce proceedings. And on the basis of the information contained in these documents, she issued an application for a freezing order. And we can start at paragraph 56 at 851. And where the judge says, refers to Immerman at 55, and then at 56 he sets out the principles that he thinks he gets from Immerman. Principles 1 and 2 are clearly justified by Immerman, which confirms that the Hildebrand rules don't confer immunity. But principle 3 is nowhere to be found in Immerman. Principle 3 is that if a wife supplies such documents to her solicitors, then the solicitor must not read them, but must immediately seek to obtain all of them from the wife and must return them, and all copies to be the husband's solicitor if he has one. Now, the direction that the documents must be immediately returned appears to be in direct conflict of the ratio of Hildebrand, which was approved, as we've just seen, by Lord Justice Newburgh and Immerman, where he said that copy documents obtained this way should be disclosed no later than the normal disclosure case. Now, a possible explanation for the judge's misstatement of the decision, in L&K of the decision in Immerman, is offered in P&ID's written opening. I'll just read it out to you. It's footnote 259 at core supplementary bundle, page 240, where they said, however, this appears to be based on a misinterpretation of what Lord Newburgh said in Chambers, where he was describing the orders that should be made where a claimant applies for an injunction. He was not laying down steps to be followed by a party or a party solicitor on his own initiative. Hence, its submission at paragraph 1042 on the same page was that the true position is probably that while a party's documents have been unlawfully obtained, is entitled to injunction requiring them to be returned. The party who receives such documents is not obliged or even entitled to return them unless until he is ordered to do so. So much for L&K. The only other case relied on by Nigeria to support a duty to return documents to the other side was Arbili and Arbili, which you find at Appeal Bundle 6, page 126. But that was a case on a different point entirely. It was an appeal against a decision by a judge hearing financial remedy proceedings to exclude illegally obtained evidence which the husband sought to put in on the eve of the hearing. The Court of Appeal made passing reference to Immerman, which they cited as authority for the proposition that the unlawfully obtained materials must be returned, and you get that from page 133. Paragraph 35, line 5. But the Court of Appeal didn't consider the question of when such documents have to be returned, and didn't address the question of whether or not the documents have to be returned in response to an application, or whether the solicitor's under a duty to return them voluntarily. Now, in taking my lords to these authorities, the question of whether or not he was in fact under legal duty to return the internal document is not before this court. This is an appeal on procedure. However, due process requires, before condemning Mr. Andrew to a finding of indefensibility, the judge must grapple with the relevant law. And I say it's sufficient for me to demonstrate there is a significant amount of conflicting authority on this subject, which needed to be addressed and which the judge ignored. Time doesn't allow me to make detailed submissions about all of those issues and why they were necessary building blocks that the judge wished to explain his conclusion of indefensibility. It's sufficient to observe at this stage that the judge didn't even acknowledge that they were issues that he had to consider. I shall now briefly return to the question of professional duties. As we've seen from their reply, paragraph 37E7, Nigeria put the case on an and/or basis, and I make no complaint about that, of course. However, by the end of the trial, Nigeria had plumped for professional obligations. There's no mention by Nigeria in its closing submissions to legal duties. L&K and Arbili weren't referred to. The only authority relied on by Nigeria was the British Standards Board written standards of the conduct of professional work. And it's worth looking at that. We find that in the supplementary reference bundle at 1108. And the first observation I would make is that Mr. Andrew might be qualified as both barrister and solicitor, but he was acting at the time as a solicitor. He wasn't practicing as a barrister, and that indeed is not possible, and wasn't possible then to hold the practicing certificate both as solicitor and a barrister without an express waiver from the Bar Council. And secondly, as Nigeria acknowledged in its written opening submissions, at footnote 990, at core supplementary bundle, page 232, these standards were only in force until January 2014, and almost all the documents that were forwarded to Mr. Andrew were received by him after that date. But the next thing you'll see from the covenant page, that is not in fact part of the actual code of conduct for barristers. This section contains miscellaneous guidance. It doesn't form part of the code of practice. Rather, it's a statement of good practice. If we go over the page, we can see the guidance Nigeria rely on, starting at 7.2. If a barrister comes into possession of a document belonging to another party by some means other than the normal and proper channels, for example, if the document has come into his possession in consequence of mistake or inadvertence by another party, or if the document appears to belong to another party or to be a copy of such a document, and to be privileged from discovery or otherwise to be one which ought not to be in the position of his professional or lay client, he should, where appropriate, make inquiries of his professional client in order to ascertain the circumstances in which the document was obtained by the professional or lay client, and B, unless satisfied the document has been properly obtained in the ordinary course of events, at once return the document unread to the person entitled to possession of it. But that must be set against the code of conduct, which is mandatory and provides in paragraph 702, as you would expect, that a client must preserve the confidentiality of the lay client's affairs and must not, without the consent of the lay client, reveal the contents of the papers entrusted to him in confidence. And can I hand up a hard copy so you can see the point?
Forgive me, this misses out a stage, doesn't it, which was pleaded, which is that you must, it's pleaded that there's an obligation to return. If the client didn't return them, then Mr. Andrew should have stopped acting. That's what was pleaded.
Yeah, but the judge has made no finding about stopping acting. The only finding made by the judge was the failure to return was indefensible. And the point I'm making, that actually the law is not at all clear as to what the duties are. And if we're looking at it from the professional conduct, there are conflicting duties. If you look at the page, bottom of the page 16, 4 pages in, the Bar's Code of Conduct sets out the duties which all barristers must obey. And then we go over to 702, bottom of page numbering C at 61. Whether or not the relation of counsel and client continues, the barrister must preserve the confidentiality of the lay client's affairs and must not, without the prior consent of the lay client, or as permitted by law, lend or reveal the contents of the papers in any instructions to or communicate to any third person information which has been entrusted to him in confidence, or use such information to the lay client's detriment or to his own or another client's advantage. So,
If your complaint is what the judge should have said was it was indefensible to retain them and continue acting, then that's another matter, isn't it?
well, he didn't. That's not his finding, though. And
Well, it was. He said that retaining them was indefensible. All that he needed to have added, would you accept, was brackets and continue to act.
no, of course I don't accept that. The judge has to start off by looking at what the duty is. I've just shown you Withers and Immerman, and they do neither of those cases say that there's an obligation on a solicitor who receives documents in this way to return
So you're
them.
suggesting that if a barrister or solicitor knows that his client not only has documents possibly improperly obtained from the other side, including solicitor's advice to them, privileged
material.
and he knows that that is continuing, he can continue to retain those documents as they come in and continue to act, sitting on them happily, and as long as he doesn't positively use them, there's nothing wrong with that. That's your contention, is it?
Contention is that this is the point that the judge should address, because Mr. Andrews...
To answer the question, Mr. Wardell, you've been asked the question, is it your contention, as my lord put it to you?
If you don't deploy them...
You just sit on them,
you sit on
they're
them. If you
obtained
don't deploy
illicitly, they're privileged documents, the other side's privilege, you know your client shouldn't have had them, you know you shouldn't have had them, but you just put them in a drawer and ignore them.
Yes.
You can just carry on acting, even though you know, and the judge has found in this case that your client did know, that his clients were using those documents for their own advantage.
He didn't know that. So can I ask you to excise that last part of the question? There's no evidence that Mr. Andrew knew that his client was misusing the documents. The evidence that Mr. Andrew gave...
What do you think they were doing with them?
Well, the evidence...
Why do you think they got them?
Because Nigeria were in a mess in the arbitration, and they wanted to send signals about settlement, and they made it clear to the tribunal that they
Well,
wanted.
the judge disbelieved your client's evidence on that as well, that it was all to do with settlement. I don't think there's actually an appeal against that finding. Last sentence of paragraph 214, is there an appeal against that finding?
Yeah.
I reject as untrue Mr. Andrews' oral evidence the documents were shared as part of settlement discussions.
Yes, sir. Can I just come back to you in that
The
second?
other thing to note is that Immerman did not concern privileged documents. It did concern the other side's documents, but they were documents, as I read the judgment, which were disclosable documents. The privileged documents had already been filleted out.
But privileged documents in this case, some privileged documents were sent direct to Mr. Andrew by Mr. Chancellor's firm in circumstances where the judge said they were sent deliberately and there was no breach. And if you're the judge considering Mr. Andrew's conduct, you have to address what he thought his duties were, and you have to do that to know whether or not there's a deliberate breach. And due process and fairness clearly requires that. Even if Mr. Andrew got it wrong, even if the proper interpretation was, as you just pointed out, even if your position is correct, and that Immerman doesn't apply to privileged documents, and therefore you should stop acting unless your client agrees to return them, the judge can't find that Mr. Andrew's conduct is indefensible without asking himself the question of what Mr. Andrew thought his duties were.
Which of the 6 documents you identified?
I gave you the
Paragraphs.
references.
Which is the one where it had been sent deliberately?
Yeah, the one that you sent deliberately can be found. Give me a moment.
Which paragraph of the judgment?
I'm just coming to that one. How much?
Judgment 325,
325 of the judgment.
page 151.
Thank you. Page 151. And I think I'll show you this document now. And that came direct from Mr. Chancellor's law firm, and the judge acquitted Mr. Chancellor and his partners of any misconduct. And therefore,
Did the judge find that it had been sent deliberately by the law firm?
give me a second. You go to 1324.
Sorry.
20 Marina solicitors wrote a lengthy
Paragraph?
324, the previous paragraph. This advised that the ministry should challenge the award on liability before the English courts and appoint a top-tier firm of English solicitors for that purpose. The tribunal also failed to consider Nigeria's submission that no land, etc., etc. That letter of advice was obviously one of Nigeria's internal legal documents and privileged, notwithstanding, on the 17th of November, Mr. Adebayo, P&ID's agent, sent to Mr. Cahill, copy to Mr. Andrew, a copy of the advice. So the judge had found that 20 Marina solicitors sent the advice, and that was passed on to Mr. Andrew. And when the judge reviews the role of Mr. Chancellor and his firm,
Where does the judge make Mr. Adebayo was yours, as it were, your
agent,
agent, wasn't he?
Yeah.
And he's one of the people who said to have acted improperly.
P&ID's agent.
Where's the finding that the letter was sent deliberately by Mr. Sashori's law firm to Mr. Adebayo?
I'll have to come back to you on that.
My understanding is that there's no finding to that effect, but I may be wrong. And I'm happy to be corrected.
I just need to,
I
I'm
don't
sorry,
know as much as you do about this case, but my understanding is that the judge has found consistently that these internal documents from Nigeria were illicitly obtained from someone within Nigeria and were passed on to P&ID, usually through Mr. Adebayo, although once or twice, or once at least, direct to Mr. Andrew.
I'm afraid I've lost the reference. Can I come back to you
Right?
with an answer to that in a moment?
Okay. Anyway, right.
So I think,
You're going to have to kick on a bit, Mr. Wardell.
yeah, I understand. So, we were looking at the code of conduct.
Yeah.
And I've been asked some questions about that. So, the question for this court is, of course, it's not whether the judge's conclusion was correct, but whether or not he should have embarked on understanding what Mr. Andrew thought were his obligations. And to do that, he needs to know what the obligations are. Then he has to go along to consider what Mr. Andrew thought his obligations were. And then he has to assess on what basis, what was Mr. Andrew's state of mind when he decided to continue acting. The judge has done none of that. None of the building blocks of his reasoning. And the judge just doesn't begin to embark on that. And the judge has found that his breach was indefensible without addressing at all what Mr. Andrew thought his obligations were. And Mr. Andrew was given no warning as to the judge, that the judge might be thinking of making a finding along these lines, indefensibility, and bearing the serious nature of the proposed findings, he should have been given the opportunity to make his own separate submissions. I think I've got the answer to the missing reference. It's paragraph 275 of the judgment, Call Bundle 138. Thank you. 275, you see the letter sent to the Attorney General. The Attorney General forwarded the letter to President Jonathan. Mr. Ovi Ukiri, one of Sasori Sound's partners, also sent a copy of the letter to Mr. Adebayo.
So it's not the letter that we were looking at 324 and 5 at all? It's
I think
another
it
letter.
is. I think there's just an error in the date in the judgment. In any event, I'll take you to that document in due course, and it's clearly a privileged document that came via a legitimate source.
It can't be the same document, surely.
No, it's a different document. Then I-
Initiation of settlement discussions, and 324 is dealing with what should happen after the award on
Yeah,
liability.
well then
12
I
months
took you
later.
to the wrong reference first time round, I'm sorry. I accept that. But here is a document coming from 20 Marina to Mr. Andrew via Mr. Adebayo. And Mr. Sasori and his firm were not implicated in the corrupt scheme. The corrupt scheme was using fictitious names. Now, ordinarily a witness's opportunity to deal with allegations of wrongdoing arise during the course of his oral evidence. And if it was going to be suggested to Mr. Andrew that he deliberately breached his professional obligations, that should have been put to him. And Mr. Andrew is entitled to assume that any criticism of him in relation to the documents would form a central part of his cross-examination. And as he states in Andrew 11, he didn't think he needed legal representation in order to deal with that point. As far as he was concerned, he hadn't breached his professional duties. But what he couldn't expect was that the extent of the cross-examination against him was to rely on an out-of-date guidance note for barristers, which didn't apply to him. And I want to show you, if I may, what was put to him. Can we turn first of all to the core supplementary bundle at page 102. And we need to look at internal page 155, starting at line 10, and where the reference is made to the written standards. At line 23, the point is put, essentially a barrister is required to make inquiries to ascertain the circumstances which the document has been obtained, etc. And Mr. Andrews says, I see that. Mr. Howard then tries to obtain Mr. Andrews' agreement that the solicitor's duties are the same, and he answers that at 156, lines 9 to 13, where he says he didn't understand that the solicitor's duties differ
So
significantly.
where are you?
156, lines 9 to 13. When Mr. Andrews says, I'm not aware of the duties differing significantly, then over the page, Mr. Andrews says what he thought the position was at 157. At lines 9 to 13, I don't think I had a positive duty to return the documents. I think in the circumstances that were explained to me, I did think there was an innocent motivation for these documents being shared. I was satisfied by that. And then Mr. Howard at that stage doesn't press the issue of his duties any further. He does, though, come back to this issue on day 4, which is page 119 into the soft copy bundle.
Well, hang on, if you read on to what Mr. Howard then puts to him, he makes the point, he then relies upon the fact of something he was told at an earlier stage, which he accepts was to do with non-privileged documents. But these documents were privileged documents.
Yes, he says
Also
that.
note, Mr. Waddell, although you told us a moment ago in relation to whichever document it is and I appreciate it's sometimes difficult to identify which one you're referring to, but whichever one it was, whether it's one at 275 or the one at 324, that it had been deliberately handed over by Nigeria to P&ID, that at 453, the judge says, there is no evidence to satisfy me that their release, that's the release of the documents to and retention by P&ID, was authorised. So the judge seems to be saying there was no evidence that these had been
I'll take you to the paragraphs, if I have time, where he exonerates Mr. Shisori and his partner, and he makes it clear in the course of his judgment that the documents that are coming improperly come via emails under aliases.
So I don't think that's correct of all of them. Some of them did, but I think he says not necessarily all of them. Anyway, we do need to get on.
Exactly. Coming on to 119 of the core supplementary bundle, please.
119.
And the bottom of page 44, starting at line 21, it's put to him that if if you receive documents from the other side which are on their face privileged, do you agree it's not for you to assess how important they are to the case? The honest solicitor is required to return them to the other side. And Mr. Andrew answers over page. I don't think I was either obliged or entitled to return to the other side. I had a duty of confidentiality to P&ID, and indeed the communications in which these documents were sent to me were themselves prima facie privileged. And so for me, these documents don't appear to be particularly relevant. I was conscious they were simply a byproduct of the settlement discussions. That's what I thought about them. I didn't much about them at all. I think I didn't do much about them. So then, that position is not tested by Mr. Howard. All that happens is that Mr. Howard poses the following question at line 13. If Quinn Emanuel sent to us a bundle of disclosure and Mishcon sent it on to me, and I see within that bundle is the advice from Lord Wolfson to you on this case, I can read it and keep quiet about it because I owe obligations to confidentiality at FRN. Is that what you understand to be the position? That's not correct in the example that Mr. Howard has given. The example Mr. Howard has given, the question for Mr. Howard for Mishcon is whether there was a clear and obvious mistake in the provision of privileged documents by Quinn Emanuel, and this is something that applies between solicitors when privileged documents are accidentally revealed in disclosure, for instance. So in that circumstance, the question would be whether there had been an obvious mistake. So
how
that's...
how does the solicitor carry on acting in a matter if he takes the view he can't read documents that he's been given by his client?
I haven't thought about that. That hasn't arisen for the purposes of this appeal. His evidence, it wasn't, I just put them in the drawer. His evidence was he did glance at them, but he felt uncomfortable doing so.
But you're in a, as soon as you take the view you're uncomfortable dealing with documents in your client's possession, that's an irredeemable conflict of interest, isn't it?
Yeah.
You can't carry on acting if you can't decide what to do with documents your client's given you. And that's why the only option you've got at that point is to say to your client, return them, you'll cease acting. Otherwise, you're in a hopeless position.
I don't think I've got a good answer to that. But if that was the reasoning of the judge, it's nowhere to be found.
But it's implicit in when he's saying that what happened was indefensible, because the decision to keep the privileged documents but also keep acting is indefensible. Now he may not have spelt it out in exactly that way, but the shorthand is these documents were retained and he knew they were being retained. He had them.
He certainly knew they were being retained, and he I accept he would have known that his client probably had more.
Well, I think,
but
isn't the judge right to say that's indefensible?
Well, it depends whether or not there's a deliberate breach of duty, or there's a misunderstanding as to the scope of the duty. If there's a misunderstanding of the scope of the duty, I would say it is defensible. If a solicitor,
my lord's just put to you that if a solicitor obtains documents from the other side by his client, and he has documents are plainly the other side's privileged documents, and he doesn't have an explanation which satisfies him that the documents have been obtained properly and privilege has been waived, then the position is the solicitor has to say to the client, I can no longer continue to act in these circumstances.
yes, but if you're
Unless you're prepared to disclose all to the other side.
Mr. Andrews' position was that he had an explanation from his client which satisfied him that he was entitled to receive the document. Now, I know you're going to tell me, well, the judge rejected that. Well, but that was his evidence, and it needed to be addressed.
Well, his evidence was on balance with what I knew. I was probably entitled to read all of it, but I didn't feel comfortable reading actual legal advice and was not 100% clear as to the provenance of any of these documents. I only knew what I had been told. Well, the judge was entitled to take the view that he took of that evidence, wasn't he?
But Mr. Andrew needs to know why the judge took the view that he did when Mr. Andrews submitted volumes of evidence as to why he reacted to the documents he received and the way he did. Otherwise, the references to other compelling evidence and building blocks to make a reasoned judgment go nowhere.
And Mr. Howard put to him pretty clearly, more than once, that he knew that they were documents that he shouldn't be reading.
Certainly put to him that he knew or turned a blind eye to the fact they'd been obtained improperly.
Yeah.
The judge found at 2:15, Mr. Andrew knew that P and ID were not entitled to see these documents. That was his finding. He didn't accept your client's evidence that he thought he was entitled to read them.
Let alone any of them being obtained by some proper means.
Anyway,
That's
you obviously don't like it, but that's
well, we've got your submissions.
You've
on
got
the
my
point.
submissions on the
I think it
point.
would be sensible to move to the next round.
yes.
Round 3.
Yeah, just finally on this ground. Query whether there really is a conflict between Mr. Andrew and P&ID. Mr. Andrew is not deploying the documents and he thinks they're inconsequential. And there's no duty to inform the other side who got them.
Well, but again, the judge found that wasn't truthful evidence.
That's exactly right.
216.
216, the judge finds it wasn't truthful. That he didn't pay any particular attention to them, didn't read them all.
And didn't consider them of much importance.
So you have my submissions of that ground too. I can't improve on them. In the interest of time, I was going to just rely on my written skeleton argument with respect to the remaining grounds. And I was going to move on to deal with section 68.4,
Yeah.
permission to appeal, 68.4 and extension of time. And I'll go on to deal with the documents shortly.
Yeah.
So, well, as for permission to appeal, you don't need me to tell you what the test is.
Yeah.
And it's got to be a realistic prospect. We submit there is. So far as 68.4 the Arbitration Act is concerned, we can see that at tab 1, the authorities bundle, page 7. In 68.4, leave of the court is required for any appeal from a decision. The other side argue that that this section applies and therefore need would have to be obtained from Mr. Justice Robin Knowles. And in light of the observations we made this morning, you put me on alert that I may have some difficulty persuading you.
Well, I think, I don't know whether anybody's looked at it yet, but I mean, I had a quick glance at the earlier judgment in the appeal that I was mentioning earlier, which was about the currency of locks where there was a section 68(4) point, in which Lord Justice Snowden referred to my judgment in the Manchester City Football Club case,
Yes.
sitting with the Master of the Rolls, about the extent of section 68(4). And
Yes.
I think that does need to be addressed in
I'm
the
going to
context
come
of
to
this
that.
appeal, because it seemed to me, on the face of it, at least highly arguable in favour of Mr. Woolen's clients, that this, although your client was not a party to the arbitration, that this attempted appeal falls squarely and fairly and squarely within the analysis in that case.
Well, I understand the concern. I'll try and answer it. We say there are three main reasons why Section 68 is not a bar to his appeal. We say that 68(4) is intended to reflect the public interest, that an arbitration should produce a high degree of finality for the parties to the arbitration. The public policy is in avoiding unnecessary expense and delay in the conclusion of the arbitration. We can see that from the P&ID case, which you find at tab 39 at 1038.
Yeah.
We can pick it up at paragraph 34, where
Yeah, this is the
this is the breath.
judgment I got in mind. Thank you.
So they cite in 34 in Sumican and Commonwealth case the intention of those drafting the Act to limit appeals to avoid the delay and expense that such appeals can cause. And furthermore, the philosophy is reflected in section 1A of the Act, which provides the object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay and expense. We would read into that disputes between the parties to the arbitration. In the specific context of challenges to an arbitral award, it's relatively easy to see how permitting an appeal to be heard against a substantive decision on a challenge under section 67 or 68 might cause undue delay or expense in the ultimate resolution of the underlying dispute between the parties. Permitting an appeal against a dismissal of such a challenge would leave open the possibility that the appeal might succeed and the court might make orders setting aside award and or remitting the underlying dispute to the tribunal for reconsideration in whole or in part. Alternatively, the appeal was against a successful challenge. Till the appeal was determined, the parties would be unable to take steps to remedy the deficiencies identified by the first instance judge and would be unable to progress the existing arbitration or, if appropriate, commence a new arbitration. Much more difficult to see, going on to 36, and much more difficult to see how an appeal against one aspect of a final costs order following a challenge under section 67 or 8 could have a similar disruptive effect upon the resolution of a dispute that has been referred to arbitration. It's true that permitting a costs appeal will inevitably require the expenditure of further resources, and the outcome will have financial consequences for the parties, but it's difficult to see how the decision on such a limited matter could cause any uncertainty in the arbitral process itself. So, Mr. Andrew wasn't a party to the arbitration, wasn't a party to the arbitration agreement, and wasn't a party to the set-aside proceedings. The appeal is the first and only opportunity he has to challenge the findings made against him in the judgment. There's no reason on that basis for section 68(4) to apply to the appeal. And as I said at the outset of my submissions, none of the adverse findings upset the order. And none of them, if they were disregarded, none of them would affect the safety of any of the conclusions reached. Imagine if 592 wasn't in the judgment at all, nothing changes. Or what if the judge said nothing about Mr. Andrews' duty to return the documents, instead focused exclusively on P&ID's wrongful use of the documents, without mentioning him by name? Again, nothing changes. Same with the findings agreed he lied. It doesn't matter what he did. What matters is what P&ID did. So this is really like a costs appeal. it results in no uncertainty in the arbitral process. And even Nigeria doesn't contest that point.
No.
Secondly, Mr. Andrews' appeal is not against the decision of the court under section 68, as 68.4 requires. Mr. Andrews is not appealing any order made pursuant to section 68. He's appealing specific findings of fact made against him as a non-party on the basis that they were made in a procedurally unfair way, amounting to a breach of his convention rights. These findings, while having a substantial effect on Mr. Andrew personally, are not the subject of declaratory relief in the proceedings, nor do they have any bearing on the substantive outcome of the proceedings. They're therefore not a decision under section 68 and do not fall within the scope of section 68.4. And you'll recall I took you to the C. Noga case earlier, which says that section 16 of the Supreme Court Act provides that appeals not against mere findings, but only if one is trying to vary or set aside the relief granted. And it very doubly makes it clear that it's only by operation of section 7 of the Human Rights Act that Mr. Andrew can have an appeal asserting his convention rights. And I say that supports a submission that the decision here doesn't refer to the unusual case where there is an exceptional appeal against a finding on convention grounds. That can't be Parliament's intention when drafting section 68.4. And it's worth quickly going back to the P&ID case at paragraph 23, which we find at page 1033.
Yeah, that was the passage I had in mind, Mr.
Thank you.
It's really the passage in paragraph 39 of the Manchester City case.
Exactly. Where is it? So, paragraph 23 is the important quote from your decision, my lord, in first instance. Citation of certain cases provoked a debate between counsel and the court as to where the line was to be drawn between decisions which would be caught by the limitation on the right of appeal in the relevant section of the 1996 Act and decisions which would not. Well, Justice Mayo has posited the example of a case management decision about how a Section 68 application should be dealt with. As I said at the time, that would seem to be an example of something which is part of the process of reaching a decision under Section 68, so it would be caught by the limitation on the right of appeal. So Geoffrey Voss suggests to Lord Panic that a consequential decision on a Section 68 application, for example as to cost, would also be caught by the limitation. Lord Panic made it clear that he was not inviting this court to lay down any general principle applicable in every case, but only to determine that this court had jurisdiction to hear the appeal from the publication judgment. I agree it's not necessary for present purposes to determine the more difficult question whether case management decisions either side of the substantive decision under, say, section 67 or 68, for example, as to how a hearing is to be conducted or as to costs, would be caught by the limitation of subsection 4 of each section. While such case management decisions may be said to be part of the process of reaching the substantive decision, the question whether the substantive decision should be published is a distinct question separate from the decision itself. In the present case, the judge's decision that the merits judgment and the publication of the judgment should be published was an application of common law principles as set out in the decision of this court in Department of Economic Policy and Development of the City of Moscow and Bankers. It wasn't a decision of the court under section 24, 67 or 68. It was therefore not caught by the limitation on the right to appeal.
Those are all cases, as it were, either side of the line, about what might be described as case management or consequential decisions, other than the actual decision itself on the section 68 or 67 application. The problem you face here is that what you're seeking to challenge is part and parcel of the judge's reasoning on the section 68 challenge, dismissing that, or rather allowing that challenge, so that it is in fact picking up the way that I had put it in argument, part of the process of reaching the decision under section 68.
Well, it's
True it is your client wasn't a party, but the fact is it's still part of the section 68 process.
if the matters that I was seeking to appeal were an integral part of the judge's decision, I would accept you'd be right. But this decision can stand with the findings against Mr. Andrew being disregarded.
That depends on how you look at a judgment, isn't it? I mean, you say this is the order that is made for the reasons set out in the judgment. And
Yes.
can you really blue pencil a High Court judgment to say, well, certain paragraphs in there aren't essential to the reasoning?
Right, he's found the irregularities in 495 through to 7. He's identified the 3 irregularities. The criticisms of Mr. Andrew's conduct, parking in a moment the debate as to what 592 says, the criticism of Mr. Andrew's conduct are nothing to do with the judge's findings of irregularity. So the reasons for the decision of irregularity are set out in black and white. Mr. Andrew is not seeking to go anywhere near them.
Don't they feed into the irregularities?
No, they don't. Perhaps we just ought to go back to that. So if we go back to judgment. And we'll see 495 to 6. We find them starting at 188. And the heading is just about 493. And the actual finding is there remain 3 things that bring the case within section 68(2)(g. Each amounted to fraud by which the awards were obtained.
Yeah.
And of course, it depends how you interpret 592, but those findings taken at face value do not involve Mr. Andrew at all. The criticism that Mr. Andrew was prepared to use corruption can go, and these findings will be untouched.
Forgive me, I read 496, reference to retaining rather than returning them as read, as certainly encompassing what the judge found at paragraphs 213 to 270.
Well, the monitoring of Nigeria's position was not part of the case against Mr. Andrew, and the judge has not found that he's monitored Nigeria's position. It wasn't pleaded, it wasn't put, and the judge hasn't found. And it's P&ID's improper retention. It's not Mr. Andrew's improper retention.
If that was taken out, as you say, the findings against Mr. Andrew, would not the NID be entitled to come back and say, well, actually, if we take those parts out, why weren't we entitled to rely upon what would be implicit that Mr. Andrews' conduct as a professional advisor was perfectly legitimate, and we could have relied on this. We told them about all these things, and he said nothing, and that was, we thought, well, that's all right then.
Well, P&ID,
Following legal advice.
P&I, well, they didn't get, they're not saying they got legal advice to that effect from Mr. Andrew. They're not saying they got any positive advice from him, saying that what they were doing with regard to documents.
It's implicit that he didn't therefore tell them that they should give them back or anything like that,
He certainly didn't tell them they should give them back.
or not read them or whatever like that.
He certainly didn't tell them they shouldn't read them. But P&ID have come to an end. They've applied for permission and didn't get it. There's no possible scope for them coming back under any circumstance.
Just to put it to you clearly, Mr. Wardell, what I need help with is whether it's possible to say for the purposes of section 68(4) that although there is a judgment which is the court's reasons for making its order under section 68, you can challenge parts of that judgment and ask this court to strike them out, but that is not challenging part of the process by which the section 68 order was reached.
I thought I'd already answered it. Forgive me.
In circumstances where the actual party to the arbitration, which was seeking permission to appeal from the judge's judgment, has been refused permission to appeal by the judge.
I thought
So,
I'd
so
answered
far
it.
as the IP and ID are concerned, the whole thing's done and dusted, and yet
Completely.
your client, notwithstanding he's a non-party, can pop up and some considerable time later and say, oh, well, I don't like this point, I don't like that point, please, as my lord put it to you, blue pencil the judgment.
I think I've accepted, and let me repeat it in case I haven't made myself clear. I think I've accepted that if the findings against Mr. Andrew were an integral part of the judge's reasoning as to the 3 irregularities he's found, I think I'd be in difficulty. Because I think in those circumstances that would interfere with Nigeria and P&ID's convention rights. But what we say is that these findings are extraneous to the reasoning, and therefore 68(4) doesn't bite, because we're not seeking to set aside the decision. That's how we put it.
Okay. Right.
And of course, 68(4) has to be read in the same way that Ray W read down the rules. 68(4) has to be read down so as to preserve convention rights. And if we can turn it round for a moment, to forget the facts of this case. Let's say we were in extreme circumstances where the judge has made, out of the blue, without any warning, very severe findings of corruption or misconduct against some individuals who appeared before him, without any proper basis at all, no pleading, not being put, no warning. So let's say the facts of Ray W appeared in an arbitration. If you're right in saying that 68(4) prevents any possible appeal, then you're saying that an individual's convention rights could be interfered with by the judge without any recourse at all.
Well, I really didn't understand that, because section 64 says is that you have to get permission from the judge.
Well, let's say the judge says no.
And of course, exactly. Well, are you saying that
If the judge says no, that you can come along and say, oh, well, you should read down section 68(4) of the Arbitration Act. I'm entitled to appeal because of my convention rights.
Yes,
Seems to be what you're saying.
it does.
Well, I find that a very surprising and far-reaching submission. Anyway, you've got
You've got the
submissions
point.
on this point.
If you don't like it, you don't like it. But you've got my submission.
Yeah.
On it.
Okay.
Would you give me a moment? Of course. Yeah, but do I understand it? Yeah, can I just go back to this, the one document I was struggling with, and see whether at least let you have the, at least so you know what my submissions are about it. It was the document referred to in paragraph 275 of the judgment. The starting point is perhaps the supplementary bundle at page 908, is it?
Supplementary reference bundle,
Yes, thank you.
908.
Yes. This is the letter.
Hang on a minute. Yeah,
So the letter from Mr. Chancellor to the Attorney General.
yeah,
That letter is referred to in the judgment at 275, which is the call bundle, page 138. And I've already shown you this, that Mr. Ukiri sent a copy of that letter to Mr. Adebayo. And at 444 of the judgment on page 178,
yeah.
well, 442, Mr. Chancellor is exonerated, as we've seen. At 444, there's exoneration of Ukiro, and we read the reference to the email of 28th of October as a typo for the document I've just taken you to. So we say that is a circumstance of a privileged document being sent deliberately to Mr. Adebayo, who forwards it to Mr. Andrew. So with that, I was going to then turn to extension of time and then deal briefly with the various applications.
You say that, I'm not sure it is. I think it's about, seems to me to be about something completely different. Unless we're showing the email that's referring to. It doesn't seem to me to be referring to this at all. I mean, to be honest, Mr. Waddell, the idea that anybody within the FRN camp would send this letter, the one you've just shown us, which is saying, in effect, we're in a terribly weak position because the tribunal is about to say, unless we file a defence, they'll proceed to an award without our having any defence dealt with, is hardly the sort of document that anybody would send to the other side under any circumstances, unless they were sending it for some nefarious ulterior purpose. So the idea that it was sent by somebody deliberately and properly just seems to me to be unlikely. Anyway, let's move on to
Extension.
the other point.
So, pursuant to CPR 52.12.2, Mr. Andrews' appellant's notice had to be filed within 21 days of the date of the decision of the lower court. If that was the date when the judgment was handed down by email, 23rd of October, then the deadline for filing his notice expired on the 13th of November, i.e. before the adjourned consequential hearing of the 8th of December. If the date of the decision was the date of the adjourned consequentials hearing, then Mr. Andrew was in time.
But it definitely is the date of the judgment. Well,
It is the judgment, yes, exactly.
And a fortiori in your case, because you're not appealing the order.
No,
You're only appealing the judgment, so there's absolutely no doubt
I agree.
that it, yes.
I
Yeah.
agree.
Okay.
There are three reasons we say why an extension should be granted. First, Mr. Andrews' appellant's notice was issued late because of a mistaken assumption that time would begin to run from the date on which this application for permission to appeal was dealt with at the consequentials hearing on the 8th of December. As he explains in Andrew 9, for your reference, paragraphs 27 to 31 on core supplementary bundle, page 37, he only realised that this might have been a mistake after the consequentials hearing, and he sought to issue his application as soon as possible upon realising this, and in any event within 14 days of the consequentials hearing. So it was a result of an innocent error rectified promptly by him. And secondly, the fact that his notice was filed late had much to do with the judge's refusal to hear his oral application for permission to appeal. Given that the consequentials hearing was listed on the 8th of December, including any application for permission, the only way in which Mr. Andrew could have issued his notice in time was to issue it before the consequentials hearing, thereby not electing to seek permission from the judge. Doing so would have been out of step with judicial guidance that it is best practice for an appellant to seek permission from the first instance judge. And that's made clear in the White Book at paragraph 52.36. I don't think we need to look it up. So we say, therefore, that Mr. Andrew acted on the reasonable assumption that in the usual way he should seek permission from the first instance judge at an oral hearing, and that if permission was refused at that hearing, he would naturally be granted by the judge an extension of time in which to seek permission to appeal from the Court of Appeal. What Mr. Andrew could not have reasonably anticipated was that the judge would simply refuse to hear his application and refuse to grant him any extension of time in which to lodge his application with the Court of Appeal. As you know, and I'll take you to the transcript in a moment, the judge insisted that a formal written application for permission to be made, but there is no prescribed form of application for such matters. And thirdly, the judge didn't have jurisdiction to consider an application for permission to appeal after the conclusion of the consequentials hearing. And that was made clear by the Court of Appeal in MacDonald and Rose, which you find at tab 32, page 889 of the authorities bundle. And we can pick it up at paragraph 21.4. If no permission application is made at the original decision hearing and there's been no adjournment, the lower court is no longer seized of the matter and cannot consider any prospective application for permission to appeal. See Lyle and Main Waring. That was paragraph 4 on page 889. And the case relied on is Lyle, Main Waring and Associated Newspapers. We find that at tab 31, starting at page 871. And it's paragraph 11. Once the dust had settled and following short written submissions on the issue from both parties, on 10th of April, Sir David emailed the parties to make plain that he understood his authority to do anything further in the case expired at midnight on 23rd of March, which is why he had acted as he had done. He said that the fact that the defendant's advisor had been wholly unaware of the application was unfortunate. He went on to say that although he couldn't give a ruling on the matter, it seemed to him that CPR 52.32 and paragraph 4.1 of the practice direction 52A meant that a judge could only grant permission to hearing and had no jurisdiction to do so after the hearing had concluded. He said that if this was right, his grant of permission was invalid, and it would then be for the claimant to apply to the Court of Appeal for such permission. The Appeal then analysed the relevant rules and concluded at 22 on page 875. For these reasons, as Sir David Eadie himself suggested, his grant of permission to appeal was invalid. Accordingly, it's for this court to consider afresh whether or not permission to appeal should be granted. So you have to apply when the judgment is handed down, unless the judge handing down the judgment grants an extension of time within which to do so. If that is done, the normal course would be for the judge to give the appellant an extension of time at which to make the application if the judge either refuses it on that adjourned hearing or decides that he hasn't got time to deal with it. And Mr. Andrew expressly invited the judge to consider his application to appeal and expressly invited the judge formally to adjourn that application. And we get that from the core supplementary bundle of the consequentials hearing of the 8th of December, which we find on page 206.
Sorry, the core,
Core supplementary,
yeah.
page 206. And so Mr. Lee on page 5 at line 21 says, what I'm really asking for today is just some sort of procedure to ensure this application can be heard properly, and indeed the Federal Republic have an opportunity to put in any representations that they wish, that is deemed appropriate. And over at page 7 at line 16 there was a debate about whether the hearing could be the week after. And Mr. Lee says at 17, the real point is we asked for an adjournment of Mr. Andrews' application, provision for, if necessary, responsive submissions, thereafter further hearing to be listed. There will also probably need to be consequential provision for an extension of time if a notice of appeal to be in the Court of Appeal is required. Now, having refused to consider Mr. Andrews' application and failing to adjourn the hearing for that purpose, the judge was no longer seized of any application for permission to appeal and was functus officio. And we say it's wrong of Nigeria to complain in this regard that Mr. Andrew failed to avail himself of the opportunity to make a request for the judge to provide additional reasons. His skeleton argument and grounds of appeal which were served in advance of the hearing, made it clear that a central plank of his appeal was the judge's failure to give any adequate reason.
But hang on a moment, let's just reading what's said here. I've read what Mr. Lee said.
Yes.
Then Lord Wilson said he's neutral. And then Mr. Howard says this is all frightfully disruptive. You invites the judge to require your client to serve an application notice.
Yes.
And that's what the judge decides. I'm going to require a formal application supported by evidence. If this is even to begin, matter for you and your client how quickly that's done, I will reserve the matter to myself.
But that's not an extension of time to make the application or an extension of time for appealing.
It must be an implicit extension of time, isn't it? Because he's inviting you to make an application.
Well, he says, if this is even to begin.
What's the point of requiring you to make a formal application and reserve it to himself if he was functus?
Yeah, and then he says, if there is such an application, I'll give it consideration. And he says at line 20 on page 9, the first thing I will do is communicate back once that threshold step is taken. And then he says again at page 10, line 5, I think it's well appreciated. Let me express it in requiring a written application as a starting point, not to indicate this procedure or this application has proper foundation. Just that if you want the court to engage, that's the starting point.
I don't see how you...
What the judge is saying is, you make an application. If you make an application, I'll consider it, and I'll reserve it to myself.
But he's not...
Now, you might well set a timetable for that, but the idea that he's funked us is just seems to me to be risible, frankly.
Has the adjourn?
It's adjourned, isn't it? I mean,
Well, you can't adjourn an application that hasn't been made.
Well, the final determination of the consequentials in this case was effectively adjourned by the judge, albeit not to a particular date, but on the basis that if, I don't know what day of the week this was, I can't remember now what day
It was
of
a
the week
Friday.
of December was, if on the following Monday your client had served the application the judge required, the judge would have dealt with it,
Well,
as he said he would.
you clearly read it differently from me. I
It
don't
can't
read
be
it
funked us in those
as an
circumstances.
implicit extension of time to lodge an application to him. I don't read it as an implicit further adjournment of the consequentials.
Well, your client made an oral application.
Yes.
As I understand it, the judge said, I'm going to need a formal written application.
Yeah.
Yes.
So what he adjourned was the application for you to make a formal written application.
In
Well-
relation to which he reserved the position to himself. And then for whatever reason, your client chose not to make the application.
The reason that no application was made because it was thought the judge was funked us. That's why it wasn't made.
Well, what if you're completely wrong about that?
Even if we're wrong about that, that's not the end of our application for an extension. The view was taken that he was funked us. Mr. Andrew then moved very quickly to get notice of appeal and an application for an extension of time, and he's explained why.
Okay.
So, dealing briefly with the ancillary applications, can I just check something?
Yeah.
May I just clarify one thing? You accept that what you're asking for is effectively relief from sanction.
Yes.
And you also accept that it's well established that in a well-intentioned incompetence, I think it's put in the authorities, isn't a ground for granting relief from sanction.
No, I do accept that.
Okay.
But you obviously fundamentally disagree. I don't read it as implicit in the judge's decision that if this is to begin, you need to issue an application, that he was thereby saying, I will thereby further adjourn the consequentials.
Well, if taking my example, you'd issue an application on Monday morning, on the 11th of December, what do you say the position would have been?
Well, we say he was funked us because he hadn't adjourned the
So
application.
your client effectively takes it upon himself to determine that the judge has funked us without going back to the judge and saying you shouldn't be doing any of that because you'd be funked us. That's a very attractive proposition.
But the rules are very clear. We say that if the only way to extend time is to adjourn the question of consequentials, including permission to appeal, to a further hearing. And if you're going to further adjourn it, you've got to say so expressly.
Well, if the judge is saying, I reserve this to myself, what is it he's reserving to himself?
Any application if it's issued. But he's not encouraging any application to be issued.
Yeah.
And he's not saying, if you do issue an application, I'm going to adjourn this consequentials hearing to enable you to do that.
Okay, right, you want to deal with the other applications.
Yes. So there were 4. We're not pursuing the unagreed bundle. The third is Mr. Andrews' application to rely upon Andrew 11 in response to the observations of Lord Justice Mails in the order of 25th of November. That's not objected to. I'm hoping I don't have to develop that.
No,
In
if it's
those,
not objected to, you don't have to.
Thank you. So that just leaves the application by Nigeria for permission to rely on fresh evidence and an application by Mr. Andrew to rely on fresh evidence in response to that.
Well, I don't think you object to the fresh evidence as such, do you?
We don't. But
Again, we don't-
but our not objecting has always been on the basis that we have a right to put in our own responsive evidence.
All right. Well, let's leave that and see what Mr. Willen says about whether or not you should be entitled to put in fresh evidence. Frankly, it seems to me this is all going to be of marginal significance to what we have to
Well, I
decide.
can't say it's central.
Right.
So, my lords, unless I can help any further.
Thank you very much, Mr. Woodall. Mr. Woodall.
My lords, there's a short answer to this appeal and there's a longer answer. Well, then, indeed, there may be a number of short answers. But the short answer to the appeal is whatever the ambit of the re-W jurisdiction, if I can call it that, this case does not fall within it. The re-W jurisdiction is fundamentally an exceptional jurisdiction that is there because this court is required to provide a remedy, even though nobody wants to challenge the outcome of the proceedings below, because something has gone so fundamentally wrong in the lower court that an individual has found themselves to be subject to severe criticism, which firstly went beyond the four corners of the case which the court had to decide, and secondly, without that individual having had a meaningful opportunity to make representations before that criticism was made. Now, this case could not be further from that sort of situation. This was a case where one of the central allegations made by Nigeria was that the award had been obtained by fraud because its opponent, PNID, had access to Nigeria's privileged documents. That was one of the grounds. And one of the central protagonists in that fraud, repeatedly named in the pleadings, cross-examined for days, was Mr. Andrew. Because although my learned friend keeps talking about PNID as being one bucket and Mr. Andrew as being another bucket, Mr. Andrew was PNID's agent, representative, for the purposes of the arbitration. The whole reason days were spent before Mr. Justice Knowles examining what Mr. Andrew had done was because his acts were attributable to PNID. And if he had wrongly retained privileged documents in breach of his professional duties, that was a basis on which the award could have been fraudulently and improperly obtained. Now, the suggestion made by my learned friends, not repeated orally, but in the skeleton, that the judge was off on some frolic of his own, that's the words that he used at the end, the peroration of my learned friend's skeleton, is with respect completely divorced from reality. The judge was deciding precisely part of the case that was put to him, and indeed put to the witness. And what was done fairly. The allegations were pleaded. The case was put in cross-examination. Mr. Andrew had the opportunity, both in an extensive trial witness statement and over several days of cross-examination, to answer those allegations. And the judge gave the essential reasons why he criticised Mr. Andrew. That he had received documents that he knew he wasn't entitled to receive, and that he had lied to the court about his reason for thinking that they were legitimately provided, i.e. the idea that they had been provided for the purposes of settlement. And that, frankly, is the answer to grounds 2, 3, 4, and 5 of this appeal. This was precisely what the case was about. The judge decided the case, and he gave the essential reasons for doing so. There was nothing wrong about that, whatever standards you apply to it. The short answer to ground 1 is that really, for my learned friend's challenge to get off the ground, he has to say that paragraph 592 was implicitly bringing Mr. Andrew within the scope of the bribery findings in paragraphs 495 and 496. That's his first of the 3 alternatives. That is self-evidently not what paragraph 592 read in context was doing. It was part of an endnote that made generic reference to the misconduct of a number of individuals and the suggestion that it was specifically making a finding that Mr. Andrew had been involved in that particular scheme of bribery is simply wrong. And once that goes...
If that had been what the judge was intending, then that would have been a far more serious matter to be referred to the Solicitor Regulation Authority than the matters which were referred.
It would have been a far more serious matter to refer to the SRA.
Effectively, it would have been a criminal offence.
It would. Not simply effectively, it would have been a criminal offence.
Yeah, it would have been a criminal offence.
And the idea that having spent pages and pages of reasoning going through all of the different schemes, that the judge then just decided in 3 words to make a finding that Mr. Andrew was implicated in one of the schemes where no one had suggested it and the judge made no findings to that effect, makes no sense. No reasonable reader of the judgment would reach that conclusion. It may be there are different ways of looking at paragraph 592, but that is not what it was doing. We would submit the best reading is that corruption was being used in a broader sense, that it meant the effectively dishonest conduct in the pursuit of gain, and there is no doubt that that is what he found Mr. Andrew did. And there's no reason, therefore, why Mr. Andrew had to be excluded from paragraph 592. But it simply doesn't make the finding that my learned friend need it to, and if it doesn't make that finding and all it's doing is compendiously referring to the more detailed findings elsewhere, ground 1 falls away with grounds 2 to 5, because the other findings, to which it makes compendious reference, are unimpeachable.
Yeah.
Now, my lord, that's the short answer to the appeal. And in a way, I could develop that and leave it. The reason I'm slightly nervous about doing that is that there is a tendency in these appeals for there to be creeping extensions, as perhaps one expects, to the re-W jurisdiction. So it's now sought to bring in Article 6, to bring in common law obligations. And obviously I'm concerned as part of perhaps my wider interest, that obviously the court doesn't, if it's going to give a judgment about the scope of the re-W jurisdiction, that it has full submissions on the points that have been
No, I think you should make full submissions.
Very good. In that case, the way I'm going to develop it is this, and I'll try and follow my learned friend's structure. So we will deal first with the law, and that will include in particular why Article 6 isn't engaged at all, but also the circumstances in which Article 8 are engaged and the requirements of Article 8. Secondly, I will then have to look at some of the facts, and by facts I mean what was put during what was pleaded and what was put during the hearing, both to demonstrate that Mr. Andrew did have full notice, but also to contextualise the reasons, because when one looks at the reasons, one does that with the knowledge that the parties have of what the actual issues were. It doesn't have to be, it might be best practice, but it doesn't have to be a fully self-contained document where you assume that the reader has no knowledge of what was actually going on at the lengthy hearing. Third, I will then deal with the specific complaint grounds 1 to 5. Fourth, I will deal with why permission to appeal should be refused as a matter of discretion, and in particular because it would impinge on FRN's Article 6 rights, which is the point your lordships were raising about, well, does it have an impact on the resolution of the Section 68 claim itself?
Yeah, I mean, I think both Lord Justice Phillips and I separately were troubled by that point.
And I do want to deal with that. And fifth and finally, my learned friend Mr. Ford is going to address your lordships on extension of time and Section 68(4), if that's acceptable to the court.
Okay, that's fine.
So in terms of the law...
just before you go on any further, I mean, Mr. Wardell, under sustained fire from this side of the court, has gone on quite a long time. I mean, how much time are you going to need to develop everything?
Well, we had a chat about it. We agreed we would take roughly half of the 2 days each, subject, of course, to your lordship.
And then give Mr. Wardell an opportunity to mop up in reply at 4:15 on a Friday afternoon.
Yes.
He very kindly agreed to that
The
opportunity.
graveyard slot, Mr. Warder. Okay, well, as long as you're, I only ask that before you sort of launch into things any further. You're not inviting us to sit beyond 4:15 or before 10:30 tomorrow morning.
No.
Okay, that's fine.
No.
Thank you.
Now, well, in terms of the propositions of law, I'll give them to you and then perhaps just develop them a little.
Yeah.
The first, and this may not be controversial, but of course, Mr. Andrew generally has no right of appeal against the findings in the judgment because he is not challenging the order. That's the Compagnia Noga point. So the only way the court has any jurisdiction is if Mr. Andrew's rights under the European Convention are engaged and have been breached. And my lords, that is important because it explains why there is simply no basis on which my learned friend can rely on what might be described as common law or English procedural protections, because the court simply doesn't have jurisdiction to consider breach of any common law protections. It has obviously a statutory jurisdiction to hear appeals from decisions, but that requires that someone is trying to overturn the decision. Or it exceptionally has a jurisdiction under the Human Rights Act because it has to rectify a unlawful act under the Human Rights Act. But there is no intermediate position where common law protections can be brought in to the Court of Appeal by a non-party who is not seeking to challenge a decision. The second proposition of law is that Article 6 is not engaged at all because the judge was not determining Mr. Andrew's civil rights and obligations. The third proposition is that Article 8 of the ECHR is not engaged at all where the court is making findings within the four corners of the case. And the fourth and final proposition is that if Article 8 or indeed Article 6 is engaged, those rights provide only basic minimum procedural protections. And in particular, they do not give a non-party a right to detailed reasons as to why particular evidence or particular arguments have been accepted or rejected. And I do say, and I will submit, that the requirements of Article 8 or Article 6 of the ECHR in terms of reasons are lower than the requirements that the English Court of Appeal in particular, applies to its judgments. And of course, one has to be careful here because anything you say about the requirements of Article 6 would apply equally to other courts in other countries that may well have different practices as to how judgments are given. It's a point made in English that civilian courts very often do give.
Well, civilian courts have tended to give, certainly appeal courts have tended to give slightly longer judgments in modern times than they did historically.
Yes.
Whether they've gone back to shorter judgments now, we're no longer in Europe, so far as the European Court is concerned.
Yes.
I'm not sure, but so far as the Court of Human Rights is concerned, a number of the civilian courts or the judgments which go to or the challenges to which go to the European Court are from what we would regard as pretty short form
Judgments.
decisions.
Yes. And indeed, generally,
140 pages of
are acceptable. Well, can I start with Gray, the case of Gray and Borek, it's an Authorities Bundle B, tab 22.
yes.
A case, obviously, that is well known to my Lord the Chancellor, as indeed it is to me, but a case that's of particular relevance because it's very close to being on point. It was it's tab 22, page 462.
Yeah.
My Lord the Chancellor was the trial judge and found that a non-party solicitor had dishonestly misled him on
Yeah.
the freezing order application. And there was then an attempt by the solicitor, who was not a party, save for being joined for the purposes of the appeal, to the Court of Appeal. And I am therefore citing a decision on permission to appeal, but I hope nonetheless in these circumstances acceptably. So the permission to appeal came before the then Vice President, Lady Justice Gloucester, and Lord Justice Briggs, as he then was, who refused permission. And it's if I could ask your Lordships to turn, please, to page 474. And you will see.
Am I right in recalling that the context was that the main judgment had already been handed down, and there was then a subsequent application by Mr. Borre to set aside the freezing injunction on the basis that it had been obtained?
Not quite.
I couldn't quite remember the detail.
The application to set aside the freezing order was before judgment on the main trial.
Oh yes, okay.
Your Lordship did set
Well, I
aside
do
the freezing
remember
order.
that,
There was an extremely long delay in dealing with permission to appeal because the court was waiting for the decision in Re W, which was itself delayed.
Yes.
And so whilst waiting for Re W to be handed down, your Lordship gave the trial judgment, and indeed permission to appeal had been refused on the trial judgment.
Yeah.
So by the time the permission to appeal is by Mr. Gray is actually comes on, the trial is over, and indeed permission to appeal on the trial has been refused. And indeed, and that's one of the reasons Lady Justice Gloucester gives, that it would be unacceptable now to be prolonging the litigation. Paragraph 34 is dealing with the question of whether or not there is power to bring an appeal against the substance rather than on grounds of procedure. But the reasoning given in paragraph 35 onwards is, in my respectful submission, instructive as to what the ambit of the legitimate appeal is. So at 35.1, Lady Justice Gloucester begins by dealing with the case of MA Holdings, which is the George Wimpey case, the planning appeal. So that was a case where a non-party wanted to appeal, but they did want to appeal the decision, not simply the reasons. And she points out that Mr. Gray was not in that position because he wasn't substantively affected. Goes on, no personal interest in the freezing order, no legal or equitable rights, only interest is reputational. And Lady Justice Gloucester then says that is enough. That is not enough to generally give you a non-party the ability to appeal. You can see that at the end. It's only if you are able to engage Article 6 or Article 8 that you would have status to appeal. And she explains that over the page, at the top of page 475, that Company Noga and Riem clearly demonstrate that the court does not have jurisdiction to entertain an appeal against findings of fact which do not amount to a determination unless effectively the whole case turns upon them. That's the sort of declaratory judgment type cases. And then at 3, Roman 3, goes on to explain that nothing in Re W provides a route of appeal in respect then of matters of substance. Article 8 purely provides procedural safeguards. It doesn't guarantee the right to a correct result. And so, in other words, what I say you take from that is that this court only has jurisdiction if there is a breach or an engagement, at least, of Article 6 and or Article 8 rights. And Lady Justice Gloucester at the end of Roman 3 makes the fair point we submit, that it's one thing that a witness whose professional reputation is at stake should not be criticised without warning and a fair opportunity to respond, which we say is what this jurisdiction is all about, but quite another to allow a professional witness to appeal simply because he or she disagreed with the criticism of his or her evidence, professionalism or conduct. And of course we say that if the only basis on which the court has jurisdiction is the breach of the European Convention, then my learned friends can't rely on what might be called common law unfairness. And that's obviously important because a lot of my learned friends' skeleton was spent referring to cases on, for example, the requirement to give reasons at common law. And we say that's just not available to him. Where does that give him jurisdiction to get before this court? He's got to show that it infringes not the common law standards, but the Article 6 or Article 8 standards. Just while your lordships are looking at Bore, could I ask you turn on please to page 476? And just to draw out some analogies with the present case. Paragraph 38, the judge found there was a complete error of unreality in Mr. Gray's contention. He didn't know what claim he had to meet, and took into account, of course, the fact that Mr. Gray was closely involved at every stage of the application. And indeed, we say that's an important factor here. We're not talking about the sort of police officer or social worker who comes in to give evidence. You're talking about someone who is sitting there throughout the trial, heavily involved in the preparation of the case and knows exactly what was going on throughout. In paragraph 40, over the bottom of that page, points out there's no indication in the Mr. Gray's affidavits that he was under any misapprehension of the case. He set out an explanation for his conduct by reference to a large quality of material. Unsurprisingly, the case evolved, and then this. But I accept Mr. Kendrick's submission that in the circumstances, Mr. Gray was not entitled to be told in advance precisely what the lines of cross-examination against him would be, or how every point would be argued. The gravamen of the allegations against him and the type of arguments had been clearly spelt out in the skeleton. And we say that that's plainly right. Article 8 does not give one a right to notice of precise arguments or lines of cross-examination. You need to know the gist or the gravamen of the allegations. Similarly, paragraph 42, in the middle of that paragraph, apparent from the judge's detailed and careful judgment, he was meticulously fair. It's legitimate for the judge to make findings of fact, irrespective of whether they were points which have been relied upon by Mr. Bore as one of the grounds in his application. Clear that he had an opportunity to deal in the course of his evidence with those, the aspects of the evidence where there were adverse findings. So again, my submission is nothing in Article 8, which means that the court can't make findings of fact, the witness has lied, that the witness has a particular motivation, provided, of course, that they've been given an opportunity to deal with them. The court's not constrained merely to commenting on the headline allegations that have been relied upon. Turning to page 478, just ask your lordships to note for now that paragraphs 46 to 48 deal with the reason the court would have refused permission even if there had been a sufficiently arguable case of breach of Article 8 rights. You'll see 4 lines into paragraph 46. Lady Justice Gloucester says it would be wholly inappropriate to afford Mr. Gray a remedy by way of appeal. And I'll come back to that at the end of my submissions. But if you see at the very bottom of that page, what the judge was doing was balancing the party's Article 6 right to finality with the non-party's Article 8 rights, and indeed over the page was looking at the fact that there was another route by which the non-party could seek to vindicate their reputation, namely by defending proceedings in the Solicitors Disciplinary Tribunal, and that's plainly something that is an important factor in whether this court exceptionally has to make available an appeal to deal with a reputational, what is essentially purely a reputational issue.
Do you rely upon the last sentence of paragraph 45 as a paragraph? Even more detailed argument, etc. There is no possibility of Mr. Justice Flay's judgment being redacted in such a way as to excise reference to Mr. Gray's dishonesty or rewrite the judgment.
My lord, I do up to a point. Can I address it in this way? Gray was clearly a case where the only basis for setting aside the freezing order was Mr. Gray's dishonesty. There was no other basis. So if you wrote that out of the judgment became nonsensical. And so that was a very strong case for saying you can't do it. I accept that in this case, you could remove the references to Mr. Andrew and the relief would still work, because there are two other grounds on which Section 68 was found to be satisfied, and indeed even on the third ground, the privileged document, although contrary to my learned friend's submissions, Mr. Andrew's conduct was plainly part of the improper retention of privileged documents. There was also improper retention by other people within P&ID, Mr. Burke, Mr. Carhill, and so even the third ground could work without Mr. Andrew. So we're not in the grey position where excising those findings would leave the judgment nonsensical or incoherent. But I do say, and this will be my submission on the discretion aspect, the problem once you start pulling at threads in a judgment is you don't know where it's going to end. You may then have other people saying, well, if he's out, I want to be out as well. And you get into a situation where there's a risk that the judgment may unravel. And
Once you start saying a judge's factual findings against an important witness in a case were wrong and should be struck out, I'd have thought PID might have something to say about that.
You can imagine my submission would be they would have no ability to do so, and they would have no legal route to doing so, and it would be wrong in any event. But the problem is the mere fact that they might well have a go, whether before your lordships, or indeed in a foreign jurisdiction where they may say, well, we don't accept this set-aside judgment because, look, the English Court of Appeal has said, actually, there's a problem with it. The mere fact that that is a possibility is enough for me to say, well, look, that is interfering with our Article 6 rights. We're entitled to finality. We've got a judgment. We don't want it tinkered with.
Would they not go back to Mr. Justice Knowles saying there's been a change of circumstances?
On a final judgment, I would submit not. That's much like a challenge to a newly discovered evidence. You'd have to come to the Court of Appeal. So my answer to that would be no. But fundamentally, my answer to this is...
Well, your short answer is that they couldn't, even if this court were to accede to Mr. Wardell's submissions on this, P&ID couldn't do anything.
Certainly that's my submission.
Improve their position, but what you say, there's always a risk they might try and do something, even if it's not in this jurisdiction. And to the extent there is such a risk, this court shouldn't countenance you're being put in the position that you face it.
Because it undermines our Article 6 right.
It's final.
Finality of the judgment that we properly obtained.
Final Section 68 challenge is absolutely final.
Yes. And my own friend, Mr. Ford, will address you on Section 68.4 and say why that is precisely why 68.4 is engaged.
Yeah.
But even if he's wrong about that, it plainly weighs in the discretionary balance that arbitration is something where finality is of particular importance. And it's another reason why the finality weighs far more heavily than anything else. So well, that's, and just to finish on 4A, paragraph 50 on page 479, we simply commend that to your lordships as a obviously right statement of the position and a strong reason why you should draw the REW jurisdiction tightly to discourage this sort of application, save in the truly extraordinary REW Popely type cases where someone finds themselves guilty of a conspiracy without having even known that that was suggested before they read the judgment.
Well, the Lady Justice Gloucester at 45 onwards, really 45 to 48, gives some detailed reasons as to why re-W wouldn't apply on the facts of that case. And you say, well, mutatis mutandis, that's the position here.
Yes, I do. Redoubled, I say, in the context of arbitration.
Sure.
That then takes me to Article 6.
Yeah.
Now, the whether Article 6 is engaged is potentially important because the rights under Article 6 are different to, and in some respects higher than, those provided by Article 8. And that's perhaps unsurprising because Article 6 is dealing with a situation where someone's legal rights and obligations are being determined, whereas Article 8 applies much more broadly simply to things that can interfere with enjoyment of life, professional reputation, and indeed can apply to a variety of effectively administrative behaviour, such as issuing criminal record checks and all those sorts of things. And one has to be very careful not to import the standards of judicial decision-making into Article 8, given that Article 8 does have this much broader application. Now, Article 6 applies on its own terms where there is a determination of a person's civil rights and obligations. And I can take that from I can take requirements for that from a recent decision of the European Court. That's Authorities Bundle B, tab 25, a decision of Grzeda and Poland, which begins at page 562 of the Authorities Bundle. Tab 25. Authorities B, tab 25.
Yeah.
The facts don't really matter. It was about the termination of a judge's membership of a council of judges and whether that was a Article 6 right. But if you go, please, to page 656.
So it's 6.
656 of the Authorities Bundle, paragraph 257.
Yeah.
So essentially 3 requirements for Article 6.1 to be engaged. First, there must be a dispute over a right which at least arguably is recognised under domestic law. So you need a legal right. This isn't simply reputation in some general sense. You need a legal right. There are then a number of requirements about the dispute being genuine and serious, and so on. But you will see that 2 lines up from the bottom, the result of the proceedings must be directly decisive for the right in question. Mere tenuous or remote consequences not sufficient. And finally, over the page, not a matter we need to be concerned with here, lastly, the right must be a civil right. Now, the issue here is that there is not, Mr. Justice Robin Knowles was not deciding whether decisively or otherwise Mr. Andrews' legal rights. Now, Mr. Andrew obviously has a legal right to work as a solicitor, but that was not being determined by, certainly not decisively determined by Mr. Justice Robin Knowles. That right will be determined in due course by the Solicitors' Disciplinary Tribunal, which will have to decide whether Mr. Andrews should continue to enjoy his legal right to practice, to remain on the roll and to practice. And in making that decision, it's well established that the Solicitors' Disciplinary Tribunal can have regard to what Mr. Justice Robin Knowles said, but it cannot simply adopt it. It has to form its own judgment based on the materials before it. And so it can't even be said that Mr. Justice Robin Knowles' decision is practically determinative or even has a profound effect on those matters. The tribunal will not only have to decide the facts, but will have to decide whether those facts are sufficiently serious to justify the striking off, the removal of that right to practice. And that doesn't follow from Mr. Justice Robin Knowles' decision. Now, as I understand it, my learned friend doesn't put it on that basis. He says there is a legal right to reputation. And he takes that from the Fayed case. Now, the difficulty with that is that what was being said in Fayed was that Mr. Fayed was engaged in libel proceedings against Lonhro, and that therefore the decision of the inspectors could effectively impact on the determination of that right. And if my lords still have Authorities Bundle B to hand, you can actually see that in Authorities tab 16, page 402.
Sorry, tab 16.
And tab 16, page 402 of the Authorities Bundle.
Mhm.
And you'll see just a couple of lines. Sorry, if you go back to page 401.
Yeah.
There's a reference at paragraph 61 to the court being satisfied the functions were investigative, didn't adjudicate in form or substance, not determinative, dispositive of anything. And there's this, they did not make a legal determination as to criminal or civil liability concerning the Fayed brothers, and in particular concerning the latter's civil right to honour and reputation. And then it talks about what they did do. And then over the page, it refers to Lonhro. And a few lines down, it says, nevertheless, whilst there was a close connection between Lonhro's grievance against the Fayed brothers and the matters investigated by the inspectors, the object of the proceedings before the inspectors was not to resolve any dispute between Lonhro and the applicants. Those disputes, and in particular the applicants' libel claims that their reputation had been wrongly damaged, were being adjudicated by the ordinary courts. And it goes on and discusses that and says, in short, it can't be said that the inspector's inquiry determined their rights to a good reputation. Now, what my learned friend then tried to do was to shift that in saying, well, if the decision impacts on your reputation, it is determining it. That is not what Fayed is saying at all. Damage to one's professional reputation is an Article 8 issue. It would only be if there was a determination of a legal right to reputation that Article 6 could possibly be engaged.
At a convenient moment.
It is, my lords. I should just mention that there is an authority which I'm going to hand to my learned friend and to your lordships, not because I want to say anything about it, but just because it touches on the points I've been making, which is a case called Crown on the application of G versus governors of X school. And it was concerned with, is Article 6 engaged, where there are disciplinary proceedings against a teacher, which result in matters getting referred to the Independent Safeguarding Authority. And it essentially said no, because the Independent Safeguarding Authority has to make its own decisions. I simply draw it, I'm going to give it to your lordships, because it does talk about what directly decisive means, and I think your lordship should have it.
Should we take that now? And,
Yes, and it's the relevant, I'll give it to my learned friends as well, the relevant paragraphs are really 67 to 84. But I just, given I've made submissions about what directly determinative means, I think your lordship should have the Supreme Court's word on what that means. You will no doubt predict that my submission on it will be highly analogous here.
Yeah.
Judges' findings may be relevant, but they don't bind the SDT.
We'll try and look at that. Okay. All right, well, 10:30 tomorrow morning, please, thank you.
Yeah, absolutely.
Yeah. Yes, it is.